I'll note that we are recording the session for people who have to leave early. And thank you so much.
Okay, and I think that we're both delighted to be here. And I'd like to kick it off by starting with Jeff and asking him what is your experience, Jeff, with what CEOs are looking for in employment contracts these days? And what are they finding as the most important provisions for them?
Thanks, Charlie. And before I get to that, thanks, Mary Kate, for the kind introduction. Good morning to everyone today. Charlie and I were having lunch maybe a couple months ago over in Georgetown, and I threw out the idea of us doing a webinar for this group on these issues. Charlie and I work together quite frequently. We have a lot of common clients. Sometimes when I'm representing the association, sometimes the execs. But because of all the work we've done together, I have enormous respect for Charlie and his colleagues, and I know they know this space frankly better than anyone, and thought it would be a really interesting webinar for us to do. But I said, Charlie, no PowerPoints. Like, I can't stand PowerPoints, for those of you who have seen some of my webinars. Let's just make it conversational. Let's ask each other some questions, and most importantly, solicit questions from you guys. So we want you to kind of interrupt and ask questions. You can post them in the chat. Mary Kate will monitor that and kind of pose questions to us, or feel free to, it's a relatively small group, to unmute yourself and just ask verbally. But we want to really make, the next, what do we have, 70 minutes, as interactive as possible.
And let me just add that I'm happy to respond to any questions that come along that we're not able to address in this meeting. So my email is cquatt@quatt.com, and any questions, just send them to me and I'll be happy to expand. Okay, Jeff.
Sure, same here, of course. And I suspect we will get a lot of questions. I've spoken on this topic quite frequently, including at ASE annual meetings and otherwise, and there's always a high interest, and not surprisingly, a high personal interest, because these issues go to your bottom line. They affect all of you personally. I've never worked on as many association CEO employment contracts as I have the last couple of years. I'm not sure exactly why that is the case, but and having worked on these my whole career, you get to see a lot of trends. You get to see what really matters most. You get to see where things break down, things that you wish were in someone's contract when they come to me. I get involved not only in the contract negotiations and the hiring process, but also on the back end when things go sour, go south with an association exec's relationship with the board or the executive committee, and then there's some sort of a separation, and putting things in the contract up front to help protect you can be critically important in that regard. And while Charlie and I work, when Charlie works for the associations, I work for both, not in the same transactions, but in most of this is going to be focused on you guys personally, and how you can structure your own employment contracts and deal with your situations in a way that best protects you. So with that as background, to answer Charlie's question, what are some of the most important provisions, I think, in CEO employment contracts? There's a ton of provisions. Some are more important than others. And you always want to prioritize your goals to focus on. You're not going to be able to get everything you want in every contract negotiation, but you want to get the things that matter most to you. But here are some of the most important provisions that I think you want to focus on. First off, the term. That means the length of the contract. How long is it? They tend to run anywhere from 2 years to 5 years. For a first-time exec, it tends to be a shorter. Probably see 3 years the most. For renewal contracts with execs, tends to be, especially when the board is very high in the exec, it tends to be longer. I'd say more like 5 years, but it varies. So the term is really important. And then how the term can be renewed. Does it automatically renew unless either party, say, gives 90 days prior written notice? Does it just end at the end, which forces obviously a renegotiation? Or it could, the association might say goodbye, it's been a good run, but we're ready to move on. There are pros and cons to both approaches. Sometimes if an exec believes that, they really need to prove themselves, but if they do, they're really going to be a high value commodity for the association, and you really want to tee up a new contract negotiation, because that's the time when you can usually get a more significant jump in your compensation and perhaps other benefits as well, but especially compensation as compared to say the year over year during the term of the contract, your base comp doesn't tend to go up that much. And so sometimes a forced renegotiation can be very helpful to the exec. At the same time, some execs want the comfort of an automatic renewal. Of course, even if it has an automatic renewal provision, some people call it an evergreen provision, it doesn't mean that the parties can't still, enter into a new contract, but that doesn't tend to happen as often. Termination, critically important. Perhaps the most important provision in an employment contract. Termination by the CEO or termination by the association. Usually for the CEO, the contract will say that it's really just a question of how much notice the CEO has to give. Basically, most employment contracts these days allow the exec to leave at any time. We just have to give a certain amount of notice, usually anywhere from 90 days to 6 months, I'd say. And with the idea being to give the association time to find a successor. Where the more critical provisions come in on the other side, termination by the association. So let's break it up into a couple of buckets: termination for cause and termination without cause. Termination for cause generally means the exec did something bad that gives the board the right to terminate them without any severance pay. So here, as you might suspect, the definition of cause is absolutely critical. Absolutely critical. There are some cause provisions I've seen that you can drive a truck through. I looked at one yesterday. We're representing the exec, and the contract, the draft contract that came over, said that one of the provisions in the definition of cause is anything that the exec does that's negligent. And that's such a broad provision. You do not want something that says negligent. Now, if it says grossly negligent, I'd be okay with that. And the rest of the cause definition was okay. There's a million different cause definitions. There is no one size fits all. I don't think I've ever seen the same cause provision in multiple contracts. But from the exec's perspective, you want to make it as narrow as necessary. And there are ways to strike a good balance that's fair to both sides. The other is a termination without cause by the association or by the board. And there's kind of, again, I would break it up into two sub buckets. What I call a midterm termination, meaning a termination without cause during the term of the contract, and then a termination without cause by non-renewal. So say the contract has an automatic renewal provision, but the board decides not to renew the contract. In both of those situations, you have to address, A, how can the board do that termination? Then B, what does the exec get in the event of that termination? Typically, for most association CEO contracts, almost always, there's some severance pay involved. So if there's a termination without cause, midterm, the exec will get severance pay. Generally, it tends to vary between I'd say 6 to 12 months of severance pay, usually paid out during the course of that term, often saying that the exec gets an additional month of severance pay for every year that they're with the association, but usually it starts out with a 6-month minimum, and it's often capped at 12 months. In the past, I used to see some more generous severance amounts, even up to 18 or 24 months. I tend to see that less these days. And then another thing that's really important from your perspective is to be sure that you're getting particularly your COBRA health insurance premiums paid by the association during the severance period. That's a critical thing that a lot of association execs omit. And then finally, in the event of non-renewal of a contract, when I'm representing the exec, I always try to get some severance pay built in. I'd say more often these days, I'm having a hard time getting the full amount of severance pay in the event of non-renewal, but I'm often able to get 50% of the amount of severance pay in the event of non-renewal. And that's very important as well. There are a number of other provisions that are important, but I don't want to hog the mic, so to speak. So why don't I turn it back to Charlie, and I know we'll cover these issues as we go along. So Charlie, in terms of the work that you do, in terms of compensation analysis and whatnot, why do you believe kind of the right compensation plan is so important to the success of the CEO and the association?
Well, in the long run, it's not just about negotiating a contract, but it's actually enjoying the experience based on the terms that you've negotiated of managing the organization. And to a great extent, you and the board should feel that if you're performing, you're being rewarded for it. And that also the the terms of the contract are ones that that you believe are rewarding you for the performance you put in and the effort you make, and at the same time recognize that the marketplace is moving and that your board feels the same way. And so to a great extent, when negotiating a contract, what I think about is what does it take for the board to be fully on board with the offer that's being made for the contract and the terms, and also for there to be consistent understanding. To me, the most critical thing is how the incentive plan will work, how you will be measured, how you will be rewarded. And many times we find that an incentive plan may say in the contract that someone has a 25% target. Does that mean you'll most likely get 25%? Does that mean that's a maximum? And some CEOs, as an example, particularly in the past, just assumed that every year they would get the full 25%. In more recent years, board members are saying, well, wait a minute, we have to measure performance, we have to have more of a scorecard. So finding terms that work for both of you, I think, are critical, and getting board agreement on what terms make sense, and also how much the package should be overall, I think is really critical, and it takes an effort to get there. This is a major, I think, a significant planning process for the CEO in terms of having the right data to support it, and I can talk about that later, but also having board agreement that whatever terms are in place are ones that they think make sense, and there are terms that you think make sense as well.
Charlie, let's drill down on incentive compensation and kind of performance benchmarks a little bit more, because obviously it's one of the things I didn't get to in my list of the most important provisions, because I knew that you were going to be talking about it as well. So an initial contract, right? You're going to set whatever the initial base salary is. That's the easy part. And then the other two parts of compensation in terms of cash compensation are bonus and then sometimes deferred compensation. And we can talk about that later. When you refer to the 25% cap, you're referring to the bonus, meaning you can,
Right.
eligible for a bonus up to 25% of your base salary. And it often will say, based on, performance metrics or goals, determined, mutually determined by the exec and whoever it is on the other side, board, executive committee, compensation committee at the beginning of the year. And I know you get involved, because I've worked with you on this stuff sometimes, in working with boards or comp committees or executive committees to structure that both the incentive compensation, the bonus, and helping to structure those goals and metrics, but also that can be used to help determine the increase in base pay year over year for the exec, right? And I know we both strongly agree that it's critically important that both sides, the board and the exec, are on the same page at the beginning of each year as to what does the board believe is most important, so the exec knows, how to best perform, and if they perform to that level, they should be compensated, whether it's maximum, base salary increase the next year or maximum bonus amount. So what are some kind of tip suggestions that you have for execs to work with their boards or exec or comp committees to structure incentive compensation programs, and how much detail should be in the contract versus how much detail should be in whatever goals, performance objectives are reached at the beginning of each year, and maybe give a couple examples as well.
Yeah, I'll just make a few points. First of all, I believe it's very important for both the board and the CEO to be engaged together in agreeing on how the compensation plan and the performance plan will work and how it will be linked to the incentive. I advise boards that when they're hiring a new CEO, they should understand in advance how the principles behind how that CEO is going to be measured and how that performance will be linked to the incentive plan. So there's clarity at both ends. And I'll just give you one example. I had a client who had a 25% incentive, and her board rated her at 98% of 100% in terms of her performance, but they only gave her a 13% incentive out of 20 because they believed that that was a lot of money to begin with. She, of course, was not happy because she didn't feel they linked together. They were surprised because they saw the incentive amount in dollars significant. And the reason behind, and I see this all the time, that that there are cases where the CEO has one expectation and the board has the other. So developing a more formal methodology, sometimes, and it doesn't have to be complicated, sometimes it's more complicated, sometimes it's less, because it depends on what the board is used to sometimes in their own compensation plans. But having clarity around what will be measured, as well as how the process will be for making board decisions about how to not only measure the performance, but how to connect the performance to the incentive, I think is extremely important. I will also say that, as I said, that it used to be the case that some CEOs expect that if the award is a target 25%, they will always get it. And other boards feel that they will say in their own world as CEOs of companies, they never get the full 25%. They always get something in between. Keep in mind that they really don't understand the way trade association incentive compensation systems work, because their metrics as CEOs of companies, if you're in a trade association, are different. Their metrics, if you're in a professional society, are extremely different because they're not used to these levels of incentive anyway. So having a basis for not only providing them with the right data on how the incentive plan should be leveled relative to percentage of base salary, but also how it will work, and engaging both sides in that is a process that we have found that will lead to extremely happy results at the end, because both parties understand in advance what the metrics will be, what the expectations are, and how that will lead to performance. The final thing I would say, and Jeff has talked about CEOs that haven't worked, what we're finding in the past couple of years particularly, a lot of it is about the internal organizational culture more than it was ever before about just reaching the metrics. We're living in an age where more and more CEOs are looking like servant leaders, that boards have high expectations about a strong internal culture. And so there is an evolution as well as to what CEO performance expectations are. And working on that before the process begins and creating clarity, I think, are very important.
Those are great points. And Mary Kay, I know you have a question, but before we get to that, just a few quick follow-ups on what Charlie just said. In terms of structuring the performance metrics and the goals and whatnot for the year, both for incentive compensation, like a bonus, as well as increase in base salary. Like Charlie said, I've seen plans all over the place, some very complex, some fairly simple. Like Charlie said, try to tailor it to the nature culture of your board and the individuals that serve on it, but be sure there's enough structure there so that everyone's on the same page, and that if you achieve what you believe are your goals, you get rewarded for it. But like Charlie also said, I'm a firm believer in you got to leave. It can't be solely metric based, because there are so many other things these days that are so important in association CEO leadership that can't be measured by metrics, like net revenues or growth in membership or, sponsorship sales or other things like that. And so make sure that there's some discretion in that formula for those things. Secondly, and I can't stress this enough, the experiences of your board members or executive committee and comp members, their own personal experiences has such a huge impact on how they view, you as a CEO. Some of it's broad. It's like the nature of the association. I see some where you have a board where all of the board members make significantly less money annually than the CEO of the association. That's never pretty. I'm sorry. I know Charlie's seen this as well. It's always a difficult situation. Whereas when you have, CEOs who are themselves CEOs of large companies, it's so much easier for the CEO, for the association CEO. That makes a big difference. And then, like Charlie said, their own personal experiences, it factors into this so much, which leads to the last point, which is you need to educate them. Virtually no association board members are experienced in association management and association compensation protocols and best practices. So you have to educate them, or let people like Charlie and myself and others that do what we do, as well as the search firm, if you're working with a search firm, can be incredibly helpful in educating them as well. And I think it's that kind of tripartite, the attorney, the comp consultant, and the search firm can really do a great job in working together to help educate the board as to these things. Mary Kate, you had a question from somebody?
Yes, from the audience. A question about post-retirement packages. Is it reasonable to expect salary and or bonus retirement? Are health insurance to Medicare age, other types of provisions there?
There is virtually no post-retirement actual compensation or benefits that we see today. But to prepare for retirement, we see an ever-increasing use of deferred compensation plans. We've even used those to provide funding for post-retirement medical, as an example. We're not, the marketplace, most of these plans have gone away. And because of the particular laws related to, and regulations, which Jeff knows very well, related to deferred compensation, you can't really have extended deferred compensation plans. So that means that retirement planning up front becomes extremely important. And this is why, particularly among the largest trade associations, but now all of them, you need to think about we're seeing more deferred compensation plans right at the beginning that will provide funding for retirement. Number two, that the use of 457B plans and also SERPs and other plans that will make up for retirement, that savings that you can't fully get because your compensation may be above an IRS limit. So that's what we're seeing. Jeff?
Yeah, I could not agree more. Yeah, back in the day, I've been doing this for 26 years, and I remember early on in my career, there was a lot more kind of post-retirement compensation and benefits being paid. That's things like lifetime health insurance, for the CEO and the spouse, and other things like that. Definitely not seeing that anymore. Agree with you regarding deferred comp, and I'm not going to repeat anything you said, but I will say that deferred comp also has a benefit. And you can do this in other ways in the contract, but where the association's board really truly values the exec and doesn't want them to leave, you got to figure out, the boards are going to figure out ways to put kind of golden handcuffs on you, but that might not be a bad thing for you if you're okay staying and there's a good reward. So, deferred comp can be structured in ways that, you don't get the full deferred comp unless you stay for the full, say, 5-year term of the contract. Things like that are not uncommon, and you can build in other provisions so that while I said earlier that typically the CEO can leave virtually at any time, you want to provide incentives and be incentivized for you to stay if you want to. Bonuses that you get, or a certain increase in base salary goes up a certain amount if you stay through 4 years of the 5-year term. Things like that. We worked on one of those recently.
Yeah, and we see regularly for some of the really popular CEOs, or sometimes when a board realizes it wants to pay more, but it can't make the adjustments all at once, you may see a 5-year contract where the deferred might be, let's say, 100,000 in years 1 and 2, 150 in years 3 and 4, and 200 in years 5. So they're weighting it to encourage the executive to stay. And at the same time, they're catching up with the marketplace.
Yeah, I couldn't agree more. We have a question. How are boards viewing CEO performance through the pandemic-driven disruptions to an association's operations?
Well, yeah, let me tell you that it's been spectacularly positive. And what has happened is that boards many of the trades did so well in responding to the pandemic that our statistics showed last year, despite COVID, if the trade associations we work with and surveyed, 2/3 of those trade associations were allowed by their board to not only give base salary increases, but give bonuses at the level that they were before. And what the boards recognized, that despite whatever scorecards they had, that they had to also add a piece related to the response to COVID, because it really shifted the priorities of the organization. So we found that for the most part, there was extremely positive board feedback. And even when in some of the areas of the food industry, as an example, where there was the restaurant industry and others related, where there was a serious issue, some of the boards gave the CEOs very high performance reviews. They still only gave them a fraction of their bonus simply because the revenues were so low. But interestingly enough, this year, everything was restored. So the answer was, I saw very positive things. And what it leads to is that, in my opinion, as we're thinking about performance, there are really three issues, or three performance categories. Number one, you set goals. How did you meet them? Number two, how do you perform as a leader? But number three, how did the organization respond to the unanticipated challenges and opportunities that happened during the course of the year that do require a shift? And that third piece is often something that's was not necessarily in the past as appreciated as much. But a really competent CEO is going to take the organization where it needs to go to meet the needs of its membership.
Thanks, Charlie. We talked a little bit earlier about the importance of educating your board on best practices and whatnot. Sometimes I find it's also important to educate them on why do you need to hire a Charlie Quatt or another compensation compensation expert. Why is it important to do so? And most board members don't understand that some of this is being driven. There's lots of good reasons to do it, but one of the reasons is driven by the federal tax code and the fact that all tax exempt organizations, including 501c6s and C3s and others, are subject to this ban on private inurement, which means you're not allowed to pay excessive compensation to insiders, which would obviously include the CEO. And as a result, the way to protect against that, to guard against that, is to follow this three-step process that the IRS lays out, which says, A, you're going to get appropriate comparability data to establish that the comp that you're paying to the exec is reasonable and fair market value. And I want Charlie to speak to that issue in a second. Secondly, that you have a group of independent decision makers rely on that comparability data in setting the exec's compensation, meaning the exec is removed from that process. And third, that the body that's setting the compensation documents that through contemporaneous documentation. And if you follow that process, including having a supportable, defensible compensation analysis, it really helps to protect the association from any private inurement and in 501c3s and C4s from what are called intermediate sanctions. So I find sometimes just even explaining that to boards can be very helpful. But now, Charlie, let's talk about kind of the comparability analyses that you guys do. I've seen more than I can count from you over the years. I know you're busier than you've ever been, you've told me right now, and I've seen more change at the CEO level than I've ever seen in my career at this time. Why don't you speak to that first, and then I want to drill down a bit on the compensation analysis itself.
Yeah, I also want to say that one of the reasons we love working with Jeff so much is that he actually understands the way associations work and other nonprofits work, and having legal advice from someone who, like me, has a lot of experience over many years doing this, creates a depth of board comfort and my comfort as a consultant working with the law firm that I think is extremely important, because it's not just what you can learn, but it's what you've experienced every single day. I'm going to give you an example. We were working with an organization in the Midwest, a trade association whose board members are all people who run businesses in the Midwest. And the chairman of the board decided that they wanted to apply a gain sharing program to the association. And probably some of you may not know what gain sharing programs are, but they're very typical in industry. And it means that every time you go above a certain revenue level, all the employees share in the gains. So I called the board. The board chair called me, and he spent 20 or 30 minutes telling me about this. And my response to him at the end is, I said, well, then we can't work with you. You're going to have to find a firm that works in your industry to create such a plan, because these do not exist in trade associations. And by the end of the conversation, he became my best friend. But I was really willing to stand back and say, you have to understand that a trade association is not a company. It is more like a political body, if you will. Think of your public relations department. Think of others that involve your research people, that provide information, that gather things together. And it's important to understand how trade associations actually pay. And it's important to understand that marketplace. And that leads also to working with the CEO and the board, and to establish the right peer group. And what we like to do is start by asking, what are the factors that we should look at to determine what a peer group is? And we always love getting input from the CEO, but ultimately we make sure that we engage at least 2 or 3 board members, especially ones that may be dubious, to get them to think and tell us what they think are the criteria, so that when we present a peer group and the data connected with it, they've already bought into the fact that it's a different marketplace. And I think this is so critical, not only in understanding the peer group and getting them to support it, but using the data from the peer group as the parameters for understanding, for supporting what is negotiated and what is agreed to as the compensation plan. And it doesn't mean you need to go to the bottom end of the peer group or the middle. You could even go above that. But having the right peer group and the right data set, I think, is absolutely the basis for having the most logical conversations with people about how to negotiate a contract. And we ultimately look at the final number. When you add it all in together, what is that number? And what are you offering the CEO? And guess what? For the most part, board members are not going to pay below the median of the market, but also it helps CEOs understand, how far up can you go, where we as a consulting firm or Jeff as a law firm would be comfortable saying we can actually support this. So there's an entire process there that, if it's thoughtful and well done, I think gets everyone on the same page. It's the facts that provide the basis for then making decisions about how to carve a compensation plan up.
So Charlie, I couldn't agree more about the selection of the peer group is absolutely critical. And there's so many different peers out there. And you guys, I've always thought, do a great job in selecting peer groups that really allow for much more flexibility on the comp. I know, like you said, most boards are not going to go below the median of that peer group. But when do you see them go above, and why? And if an example wants to continue.
Yeah, contract renewal as an example. A CEO has obviously performed well enough that they want to renew the contract. There's an opportunity, if the CEO is below the market, to at least bring them to the market. But we usually design the plans to allow the CEO to go above the market, particularly through the use of the variable incentive plan. For CEOs who've been there for a very long time and whose board members just love them, it's not uncommon for the board to want to push it to the 75th percentile. And it's also a case that for CEOs who are clearly recognized in the marketplace as being very special, board members are willing to pay more. So I think it's part of a negotiated process. But I would say that once you go into the third year, the second contract renewal, in other words, this is the third contract, boards definitely start getting more comfortable in some cases of going higher. There are other boards, especially from some of the more conservative industries, who simply want to pay at the median, and it's hard to go beyond that. But we've always been able to push it a little bit by adding an outstanding factor to the incentive plan, saying, fine, we'll keep the incentive at median, but if the person performs really well, they can go above. Jeff, what has your experience been with that?
Yeah, first off, I completely agree with that. A couple of things to keep in mind when we're talking about peer groups, and whether you're at the median or going up maybe to the 75th percentile. Keep in mind we're talking about total compensation. It's right. Not just base salary, and all the private enrollment stuff I talked about a few minutes ago. That all relates to total compensation, base salary, bonus, deferred comp, and keep in mind with deferred comp. It hits the book, so to speak, in the 990s in unusual ways that can show up one year where it looks like there's this massive spike in compensation, when we know the practical reality is that's not how it works, but that's how it shows up. So just keep that in mind. And another thing to keep in mind is that if you do unfortunately have one of those boards that is really never likely going to give you the maximum incentive bonus. As much as we're talking about incentive compensation, and as much as Charlie and I love incentive compensation, if you're in one of those boards where it's not likely to happen, then if I was advising you, I would say, let's get more in the base salary. Let's try to take some of that. You have a total amount that a board is likely going to be able to give you, and that's supportable by Charlie's compensation analysis. How you split it up between, base, bonus, and deferred comp is up to you. There's different pros and cons, but one of the reasons you might want to put more in base and less in incentive compensation is if you don't think your board is likely to give you the maximum.
Yeah, and let me add, I've got a couple of other strategies that I use. One of them is to raise the incentive to a higher level with the knowledge that it's not likely. So let's say I'll give my example, my 25% target. In a case that Jeff is talking about, I might say that 25% is a target, but there's a 40% maximum that the CEO won't necessarily expect, but the CEO can still count on that 25% for standard performance, and there's an opportunity to give more. The second is that to design a plan where the target itself goes up, because the board is more likely to, those kinds of boards will generally pay a target, but some of them won't pay it outstanding. It's also the case that half of the CEOs we work with know that they're never going to get the top award. They don't expect it, but we've designed the central award to be one that they do expect and the one that they do think is competitive. So there are strategies with dealing with that, and it's very similar to what you see in the corporate world. So I think you can find ways of working through that. To Jeff's point, if a board is uncomfortable about large levels of incentive compensation plan, there have been cases where we've cut back 10% and added 10% to the base salary range, and so there's less at risk. And so I think, and especially for those of you who work with professional societies, often their board members are not ones maybe from the academic world or from other sectors where they don't get incentives at all. And they tend to look a little bit more askance in these things unless you develop them with their input.
I couldn't agree more. I see that all the time.
If I can shift, a lot of my clients are experiencing situations where they're thinking of merging with other trade associations, or there are other things that may be taking place during the tenure of a particular CEO. How are contracts evolving to deal with the potential idea of a merger, loss of a position if you do merge, and so forth and so on?
Yeah, it's a great question. And I've worked on association mergers my whole career, working on several right now. And I mean, first off, one of the biggest impediments to association mergers is having two CEOs where one of them is not ready to go or not ready to retire.
I'm dealing with that now. Go ahead.
Yeah, me too. Dealing with one, and the reason it's finally coming together is that one CEO is getting ready to retire, and so they're going to stick around for a year and then roll off, and the other one will take over. That's kind of a perfect scenario, but it's not always perfect, right? And it's ultimately the boards and the members that decide about a merger, not the CEO. Now, hopefully, usually the CEO is very much in the middle of that or leading the process or whatnot, but it's not always the case. So one thing I've always put in to contracts as a protection for execs is that in the event of a merger, and when I say merger, we're talking about any combination, could be merger, consolidation, asset transfer, and dissolution, whatever legal form it takes, bringing two associations together and making one, or sometimes even three associations together and making one. If the CEO either loses a job or no longer has the CEO position, then we treat that as a termination without cause, and the exec gets the severance that they would get in the event of a midterm termination without cause. That's a really important provision to put in there. And one other thing, keying off of what you said a few minutes ago, Charlie, we talk a lot about the boards and the boards making decisions, the board setting compensation. And in many associations, it is the board. But in many associations, and it's not just like the decision to hire or a decision to sign off on a new contract, that's almost always approved at the board level. But for so much of the annual performance review, and sometimes even the annual setting of a base salary increase compensation or bonus amounts, it's often driven by a smaller group, a compensation committee or an executive committee. Sometimes it has to be approved by the board, sometimes not. My experience and recommendation to you guys is you want wherever possible, you want those decisions to be made by the smallest group possible, and particularly the people that you work most closely with, namely the officers. And sometimes the comp committee is, the chair, the vice chair, or chair-elect, and the immediate past chair, or something like that, or it's the three senior officers, or it's the executive committee. Those are the people who know your performance the most, who you have the best relationship with typically, and you're more likely to get better numbers, better increases, better bonuses if those are the people either making the decisions or at least making the recommendation to the board. I really don't like the whole board being involved in that process. It can get really ugly and politically difficult, and usually it's not in the exec's best interest. Have you seen that as well, Charlie?
Yeah, I would suggest several things. First of all, we won't do any plan without involving opinions from both the CEO and the board. You should be part of the process in setting sort of the structure. Secondly, I would say that we're advising typically a group of two or three people to really work on this rather than the full board, because it's usually board leadership that's most familiar with the CEO's work and what they're doing. And it's certainly the case as well that the CEO should be typically is actually the person who fleshes out the performance scorecard, not the board. But working with some of the bigger trades, particularly, they like the idea of having, say, the three board leaders work with the CEO and his or her team to develop the scorecard and performance metrics for the year. And at the end of the year, I strongly advise that the CEO not only present the results, but also for each result provide how they would rate the result and give the context why, but also provide a short self-assessment of their leadership over the past year, kind of a state of the union of the organization over the past year, where it went, what it did, what it didn't do, how they were engaged. So they have an opportunity to present from their perspective how they led the organization over the past year in a very subtle way, but after all, many of you are adept at influence in doing this. And also making sure that you have one or two board advisors who are close to you, people that you can talk to and solicit their input. You want as much as possible to engage people, and we wind up doing interviews, as an example, with the board leaders, and providing a lot of input so that when plans are set, it's based on input from both sides. And I think that can make a huge difference, because they will advocate, board leaders will advocate for what they believe is the right treatment of the CEO if they're on the same page. The rest of the board members sometimes just don't know as much because they're not as much engaged. Every board is completely different.
Yeah, couldn't agree more. All right, let's pivot, Charlie, and let's talk about common pitfalls, both from your perspective in compensation plans and from my perspective in employment contracts and the contracting process. Why don't we start? You want me to talk first? Okay. So what are some kind of common mistakes or omissions in employment contracts or in the process? One I just talked about, what is the body who's evaluating your performance, setting that compensation? You want to keep it as small and close as possible to people that you work most closely with. Not having any severance pay in the event of non-renewal is a trap that, again, I having a lot more trouble when I'm representing the exec getting the full amount of severance, but often can get 50%. Another one, I mentioned this earlier, a cause definition for a termination for cause being too broad. Big mistake, because if an association board wants you to go and they think they can do it without severance, it's a really dangerous situation for you. And another really important one, we see this more in the professional associations than the trade associations, but micromanagement of execs by boards is a real problem in a number of associations. It's a horrible situation for a CEO to be in. If any of you have ever been in a job where you've had that, you know exactly what I'm talking about. You can't fix culture and everything like that through the contract, but there are certain things that you can do to help protect yourself. And to me, one of the most important is to have a provision, and I put this in even when I'm representing the association because I believe it's so important to healthy association governance and management, which is a provision that says the CEO alone has the sole authority for the hiring, firing, compensation, promotion, et cetera, of all other staff of the association, subject to budget set by the board. It's really important that you have that in there. And if you do, and I've seen plenty of execs use that to point to kind of get the board to back off on hiring and firing and promotion and other issues. When board members, even officers, get involved in that, it's ugly and it never goes well. There's a lot of other things I could say, but Charlie, why don't you tell me a few mistakes?
Right, yeah. Let me just offer one addition though to what Jeff just said. If you're a 501c3 or even a trade association, while you may not have authority over executive compensation, as a 501c3, you are liable to the IRS for the compensation of what are called disqualified persons. And they could be the CFO, the general counsel, and others. And so it's prudent to be able to let your board know that your compensation practices are reasonable and are within of your senior most people, particularly since your 990s are being reported. We work with some boards that insist, and the CEO knows in advance, that their committee will review the compensation of the highest paid people. From my perspective—
Wait, before you move on, let me just comment on that because that's a great point. I'm glad you said it. So what Charlie's talking about is basically having a compensation analysis, not just for the CEO, but a separate analysis for the rest of the staff, particularly the senior staff. It doesn't happen as much as I wish it would happen. What Charlie's talking about personal liability has to do with these intermediate sanctions penalties that are applicable to C3 and C4 organizations, and where the IRS can levy penalties on those who set and determine excessive compensation of insiders. And if the CEO is setting the compensation of other senior staff and it was later deemed by the IRS to be excessive, there are penalties that could be assessed on the CEO. That's certainly a good reason to do the compensation analysis. But frankly, well beyond that, even in 501c6s where they don't have intermediate sanctions, it's a very good idea and a good practice to do that. Not necessarily every year, but maybe once every few years. Really important process, and it's going to be helpful for so many reasons. It helps with staff retention, valuing staff, letting them know, that they are being compensated fairly and within appropriate benchmarks, and it helps to let the board know that while CEO has the sole authority for setting compensation, it's being done within a framework of a compensation analysis.
Well, particularly since the board is given the 990s and they are given the compensation of the highest paid people, for the board to know that you have a consistent process. From my perspective, if you ask me what is the biggest mistake, and I will just say very simply, not having a system. If you have a system, you've got a peer group, you use surveys, you have an established process for making decisions about compensation. It goes on an annual basis. There are formal committees connected with it. There's an annual review of your compensation and performance. There's an opportunity for getting a salary increase if the marketplace has gone up. So having a system in place really positions you well. I remember a well-known congressman who was the head of a trade association for 4 years had never gotten a board increase because he was too polite to bring it up. And the board never thought about it because he simply didn't have a process in place. So having a good process that both of you agree to, it's like everything else. If you have a good process and it's been thoughtfully developed, it solves a lot of problems.
That's exactly right. Another mistake I see is not striking when the iron is hot. If you have a great relationship with your current set of officers,
yes,
jump on that, take advantage of it. Even if your contract has 2 more years on it, if they really like you, I've seen it many times, and they may well be willing to do a new contract. And a new contract, when they like you, is the best chance for you to make a significant jump in your compensation. I know we have a couple questions about deferred comp, but before we get to that, Charlie, can you just speak briefly to kind of the process of you doing a full compensation analysis versus updating your compensation analysis each year, particularly for the CEO, perhaps for senior staff as well, and why that's important and what's involved?
Yeah, full compensation analysis is pretty straightforward. What we do is we first understand the compensation package and review the contract. Secondly, we interview the CEO. to understand what the CEO's perspective is about their compensation, as well as what criteria they would use for establishing a peer group. We then interview between 1 and 3, typically 3 board leaders independently, to have a similar conversation with them. We use that as the basis for establishing a peer group and get them to agree to that. We also use backup data. Sometimes we use the CEO survey update data to just demonstrate that the peer group isn't cherry picked, but it really does reflect the marketplace. Then we do an analysis of the CEO's compensation relative to this peer group and point out from an item by item basis, the base salary, the incentive, the deferred compensation benefits, how they compare to the market. And typically after we've done that, we provide observations and then present that first to the board chair or the chair of the compensation committee to see if they agree to it. And if they do, then we move it on to the full committee, let's say. Often we're working with 3 people, and then we ask if they're willing to share that with the CEO. And by the way, this is another mistake, I think. I believe in transparency, and given the fact that CEO Update provides all kinds of information, I believe that the board or the committee of the board should be willing to share the report that we do with not through us necessarily, but with the CEO, and not hide it from them. Sometimes they're very afraid to do that because they're afraid that the CEO is going to ask for more money, but I think that's a best practice.
Couldn't agree more. I dealt with that situation last week where the executive committee is not willing to share your report with the CEO, and I strongly disagree with that for sure. Mary Kate, what were the questions that were posed to you?
2 questions on deferred comp. One more broad, asking a bit more about how it works, how it's structured, and some examples from the clients.
Well, there are 2 forms of deferred compensation. There's the 457B plan, which has a maximum every year. It's like an additional 401k plan for executives. This year, the maximum is $19,500. This is a plan all of you should have or consider if you've got room for it. Secondly, the 47F plan, F as in Frank, is a deferred compensation plan that is paid out. It's typically there are annual awards put into a plan, and it's paid out at the end of a vesting period, which is required, and it requires you to stay through that vesting period or else you forfeit that amount of money. Those are the 2 plans. The 47F plan should be designed in such a way that it actually brings you above that it brings you above the median of the market, or else it's just delaying compensation you should be getting now. It's very commonly used, and it does provide a lump sum at the end of the payment. I should point out for those of you who are in the higher income bracket that there is a 21% excise tax for anything over $1 million that your board is going to have to pay. But those are the 2 plans. They're extremely commonly used. And if you look up 47B or 47F on the internet, I think you get a general description of what they are. If you want more information, you can always call either me or Jeff. Jeff understands these plans well to get more information about them.
Perfect. Thank you. Mary Kay, what was the other question?
The second question was a specific question. I have a deferred comp plan that pays 40% of my final year's total annual cash comp for 20 years. My ex-com links my deferred comp and annual salary increases together at the comp review time. The result is a lower salary increase relative to the market. How can I get them to uncouple these 2 in their minds and focus on my annual increase bonus relative to performance outside of the deferred comp plan?
Well, you can request that. I think you need to start by looking at the entire package and have them understand that base salaries do go up regularly. But I think I need to know more about the plan design. But I think you have to start by getting them to rethink about what the purpose of each component was and whether they want deferred compensation linked to performance as well. As an example, for a number of our clients, if there's let's say a 30% incentive compensation award every year, there's a 50% more that goes into the base salary. So that means into the deferred. So if they're getting a 30% incentive, they're getting a 15% more in deferred compensation. If they get 29% incentive, then they're only getting 14,500. So they are sometimes linked together, not always linked together. It's really a matter of looking holistically at each plan component and asking, refreshing the entire process and asking what are the goals for each of these components in the plan.
Perfect. Charlie, getting back to the question I asked you before, we never really got to the second part of it. You did a great job explaining kind of the process that you go through for an initial compensation analysis for a CEO. But talk for a minute about kind of annual updates. So, an association's board, comp committee, executive committee that's looking at, obviously the performance metrics and goals and how the exec did and how the association did, that's going to be, the number one factor that's going to factor into that. But sometimes they also want to know, okay, this is year 2, this is year 3, say of a 5-year contract, how is his or her comp looked compared to the market? And the exec often wants to know as well. So what do you think is the value and importance of doing an annual update as opposed to a new full, and what's involved in that?
There are 2 approaches to updates. One approach is because our firm, and you're welcome to participate in it, but every year we do a survey of hundreds and hundreds of our clients and get other data to understand how the marketplace is moving in general. And because we have good survey information, we can write a simple letter to say that we think the compensation in year 2 after a full review should move, the market's moving about 3%, let's say. And so, and that could actually be added to the market value of the plan. For some of our big clients, like PBS and others, we do annual updates because the media market, as an example, is moving more than 3% a year. CEO Trade Association was moving more than 3% a year. But for many of our clients, we update the actual peer group every other year. But in those alternative years, and that just means taking the survey, the peer group, and updating the data, first making sure that you haven't changed and there isn't a need for a slight modification of the peer group if you have somehow grown or something has changed. But I would say on a regular basis, every other year, just getting a letter or some data showing that the market is moving by X is very helpful, because a lot of base salary increases are usually based on what is the organization doing for the rest of the staff. If the organization is doing 3% for the rest of the staff, it would make sense that they're going to do 3% for the CEO as well. Having market data might show that the CEO market is moving more. So having a periodic refreshing of the peer group, I think, makes sense. But for big clients, we do it every single year. For others, we do it sometimes every other year. And we provide data to tell them how the marketplace is moving.
And you can also tie that into your contract. I mean, it's not the norm. I don't see that often, but you could put a provision in there that requires, the board executive committee to do that annual update, and to, that your, base salary will go up, by whatever that the market shows that the market has gone up, maybe up to a certain cap or something like that. It would be a really smart thing to put that in there. Like back in the day, you used to see provisions that said, that base salary would increase would be no less than, the rise in CPI, the inflation index, consumer price index. I don't really see that much anymore, maybe because inflation's been so low for so many years. But having some sort of a benchmark to say it's going to go up a minimum based on that annual update could be very helpful to you. And of course, you want to make sure you also have a provision, which I always put in there when I'm representing the exec, that your base salary can never go down without your consent. Without your consent, we did see some of the CEOs take pay cuts last year during the pandemic because they were giving pay cuts, to the staff or laying people off, and they felt that it was the right thing to do. But you want that to always be voluntary in your part, to not have the board be able to mandate that.
The one piece of advice I will give you is, don't do this alone. As it's time for you to negotiate a contract, you need to have someone that you can work with, a trusted board advisor, a lawyer, and a consultant. But I think you need to make sure that you've got someone that you can talk to who can reflect on what you're trying to achieve and help you think through how you can best go about doing it. And I think sometimes actually engage, even informally engaging someone and to help you think through this, I think is very important.
Yeah, it's really critical that you have the right process and structure in place. And, in some associations, particularly larger ones, that's kind of a well-established process, but that's not always the case. And like we said earlier, most board members have no clue what the norms and the best practices are here. So if it's a new hire, the search firm often plays the search firm consultant plays a really helpful role in helping to structure what the process is. But compensation consultants like Charlie and legal counsel, both for the association and for the exec, if they understand association norms and best practices, can make sure that there's a good, healthy structure put in for all of these things. And it's really, really, really important. All right, Charlie, we have about 10 minutes left. Let me ask you, so what role do you play typically in the contract negotiation, whether it's a new contract or a renewal contract? And what do you think is kind of a helpful role for the compensation consultant to play?
Well, I'm at a stage in my career where I'm old enough and experienced enough that I'm actually able to develop the kind of relationship with the board members I'm working with that's trusted, and they're willing to let me suggest. I do this almost every day, but I work with the CEO and the board, and I'm almost as a negotiator in some cases, and I'm willing to suggest after I do my market analysis what I think would be a compensation plan that might work for both sides. Or sometimes I will listen to what they have to say and provide them with some feedback as to why I think something may or may not be a good idea. As an example, and sometimes we will actually develop 2 or 3 compensation models for a new contract and give the pros and cons of each. So one might be a lower incentive and one might be a higher deferred and so forth and so on. But sometimes the board will come back and give me a contract for a CEO that they just love. That's slightly below the median of the market because the market has moved and they're nervous about moving it up too far. And I might make a suggestion or two to them. So, and I will also sometimes go to the CEO and say, I think this provision is something that the board is not going to support, and I won't assign particular board members, but I'll say I think they'd be much more favorable to this versus that. Would that make sense to you? So again, it's at a stage in my career where I'm comfortable enough with certain boards that rely on me for advice. But at the end of the day, I want to make sure that they really agree to the peer group and that I can persuade them that the data I'm giving them makes sense, because that's the basis for all of this. And when you don't do that kind of homework, and sometimes they will push back and they will say, they'll say, well, that organization is way too big. I'm sure it's skewing the data, take it out. And sometimes it's not the highest paying organization, but I'll say, fine. Or I will also say, I've included this, and here's the reason why. But I found them to be very reasonable if they trust that you really understand this marketplace and you understand how it works. I think Jeff is in the same position. It's the experience. And I'm not trying to sell myself. I'm just saying that whoever you use, you can't. Being an effective lawyer or compensation consultant is going beyond being a technician. It's someone who, like a general counsel of a company, is someone who doesn't tell you what you can't do legally. They tell you how you can get something done within the law. And to a great extent, what you get with maturity is you understand the bigger picture and what they're trying to achieve. And you try to help them come up with a solution and an offer that you think will make them happy and make the CEO happy. To me, that's when we're happiest about what we do, and that people trust you and trust that you've got integrity and you're applying it appropriately, but you're really interested in a successful outcome.
Charlie, that's a great point. I couldn't agree more. And kind of two corollary points to make there. One is the best contracts and the best compensation structures are ones that provide a win-win for the exec and for the association. Whenever it's too one-sided, it never works out well. If it's too one-sided in favor of the exec, you get boards that get frustrated and angry later, and then it tends to sour the relationship. And if it's too one-sided in favor of the association, it's likely going to force the exec out and certainly create a lot of consternation. You want to find structures that are win-win. And to another point to make that's really important, I'm representing exec right now, and I asked who the association's legal counsel is, and I know who he is, and he's got a lot of experience with association CEO contracts. And we were going through, kind of his wish list of what he's looking for, and he had some things on there, and I said, look, these things sound good. Here, I make some suggestions, but I said, I wouldn't put these in here. I said, these are not norms. These are not best practices. These are kind of an overreach. And the association's counsel is going to know that, right? People that do what I do, we know what the norms and best practices are. And so, we can say, yeah, what, that's acceptable. If I'm advising the association and, someone's pushing for this, I'll say, what, that is kind of the norm. And yeah, I think we should agree to that. If it's way outside the bounds. But sometimes some of my biggest, most difficult negotiations, for instance, if I'm representing the exec and the association's legal counsel, or vice versa, I've seen it both ways, doesn't really understand the norms in this area. Maybe it doesn't work with associations. An employment lawyer is representing the exec who really only works with for-profit corporations or something like that. It's really frustrating because they don't understand the norms and the best practices, and it can be sometimes lead to very difficult negotiations.
The last thing I'll say is where a lot of the CEOs really like the advice is when the board gives the performance metrics and they ask me, what do I think? And in some cases, I'll just say, I don't think they make sense. As an example, every year your membership has to increase by 0.5%. I will tell them that's not the way the world is working now. You can't really count on that. You have to really look at the reality of what's going on. So again, I think there are ways that a third party can see things that others don't. And you just have to be comfortable enough to tell your honest opinion. I have no agenda, and Jeff doesn't either. I think at the end of the day, if you're defending one person or another, or you're representing one person or another, that's your main job. But in the long run, you're really helping the organization, because the most important thing for an organization is to have the right CEO and be able to keep them motivated when all is said and done. And if you really think about it, that's what it's all about. And figuring out how to do that in a complicated world is not always easy, but it's fun.
And if you have the right, initial compensation that's within the market ranges, and you have the right incentives that, cause the association CEO, to work toward the goals that are the same as the association's board, and the CEO gets rewarded for achieving those goals, those are good, healthy win-win relationships that tend to promote longtime CEOs and a lot of success for that CEO. Unfortunately, Charlie and I see a lot of the opposite, which is unfortunately never healthy for an association. One other point to make, there's generally, I've told many clients, there's one kind of pot of money that the board is usually willing to spend on the CEO each year, right? And you can divide that up lots of different ways, between base salary, incentive compensation / bonus, deferred comp, other benefits, all of which have money. A lot of things that we used to see a lot more, like car allowances and spouse travel and first class travel and, private club dues and other things that are that's still common, like an annual executive physical for the exec and things like that. But all of that stuff costs money, right? How much you can spend on professional association membership dues and conferences and travel and stuff like that. Everything costs money, so you need to pick and choose, if you're the CEO, which you are, what's most important to you. Because you're not going to get everything. And in the end, a smart board or executive committee or comp committee is going to figure out the cost of everything and say, look, we'll give you this overall amount, but we're not going to give you more than that. So you need to figure out what works for you. And probably the most important breakdown, and we've talked about this already, is the split between base salary, incentive compensation, and deferred comp. And there are pros and cons and considerations for how to structure that. Like Charlie said, I like, when Charlie, or particularly Charlie, comes in and says, kind of, here is a few different options, and the pros and cons. Maybe the total comp is the same, but different ways to divide it up, depending on where you are in your career and your goals. First time new CEO, toward the end of your career, really focused more on retirement. Different structures are going to make more sense to you and to the association. Do we really just did one with representing the association where we have a deferred comp plan. I worked with Charlie on this one, and the deferred comp doesn't vest unless the exec stays for the full 5 years of the term, because they really want her to stay. And that's really important. So keep all of those things in mind. Charlie, we got about 1 minute left. Any closing words of wisdom, advice, or warnings?
I think one strategy for increasing your compensation, especially if your base is pretty much in line with the market, is the deferred. Because you can argue that you're happily the compensation works for you, but you're not getting enough in retirement if you have a very modest savings plan. And sometimes deferred as a retirement vehicle can be appealing to the board because it's not additional cash, but it's something that's more of a holistic way of thinking about giving you opportunity for a better retirement. So I think sometimes you can use that as a vehicle if you feel that there's going to be more resistance to increased cash compensation at a more substantive level. Jeff, what's your final?
It's a great point. And at the same time, like I said, everyone's situation is different. So if your retirement plan is really more, you want to take advantage of the super hot stock market that we have, and you want to be able to invest more in the market and use that toward your retirement, more deferred comp might not be, the answer for you. In fact, you may want to have just as much in base salary as possible, as you can pull that cash out, even though you're going to get taxed on it right away, and invest it in the market. So there's no right or wrong. Everyone's situation is different, but keep all of those considerations in mind. All right, Charlie, we are at the end of our program. I want to thank you so much for doing this with me. This was a lot of fun.
It was fun, Jeff.
Hope all of you guys enjoyed it and got a lot out of it. Feel free to reach out to Charlie or myself with any follow-up questions. And Mary Kate will turn it back over to you.
Thank you so much, Charlie and Jeff. This was tremendous and really helpful for all. I can see based on all the comments and great questions people have. We will send around this recording later on. And thank you so much for joining us. Have a good afternoon, and we'll see a lot of you at the Summit Awards tomorrow.
Take care, everyone.